I'm Dr. Jo Hunt, and I am a reader in European law at Cardiff School of Law and Politics, and I'm also a senior fellow under the UK in a Changing Europe project. Since the 1970s, the European Union has adopted a body of employment law, creating a set of minimum standards across the European Union. And there's a reason that they've done this that is linked to the economic purpose of the Union. And that is that if we set a minimum standard, all member states, all countries have to comply with that minimum. And no one state can steal a march on the other by undercutting, by rolling back these basic protections. The core and the focus of the original treaty that set up the European Union was economic. However, the treaty wasn't silent on social matters. There were provisions in the original treaty dealing with social policy. The treaty said that the member states, those countries that were participating in the EU project, had to promote the improvement in living and working conditions, and they would work together to promote social issues. There was even some provisions in the treaty about social matters, but no real ability to make laws in this area. At this point, social policy, things to do with employment, working conditions, health and safety, pensions, education, these were very much still national matters. There were some provisions in the treaty that were held to be legally binding, that created legal rights that could be used before courts and that you could go out and rely on. And they were in relation to sex discrimination, equal pay for equal work. In the 1970s, we start to see a change, though, a step change, and we start to see laws being made by the European Union in areas of social policy. And we see the development of minimum standards, all in the area of employment law. And so we see there measures to do with maternity leave, paternity leave. We see protections if your company has been taken over by another company. And we also see a large body of health and safety legislation. And it was also the basis for the introduction of the Working Time Directive, that the hours that you work was seen as a health and safety issue. And this piece of legislation sets weekly maximums of hours that workers can be required to work. It also creates rights to paid annual leave and rights to rest breaks. However, when this piece of legislation was being adopted, the UK wanted to ensure that there was some flexibility. And so they've written into it various opt-outs. Now, what it doesn't mean is that the UK can opt out completely, but what it does mean is that individual workers can agree with their employer that they are going to opt out of some of the rights that are provided under the directive. And it's up to each member state whether or not they make use of that opt-out. What we have to remember is that when this legislation is being made, it is being created using the different institutions of the European Union. And those institutions reflect different interests. So we've got the Commission that reflects the EU's general interest. We've got the Parliament, the European Parliament, and that will feed in. And that represents the citizens' interests. And then we've got the Council. And in the Council we have government ministers. So there will be an elected government minister from each of the member states in the Council feeding into that decision-making process. Social policy as we understand it at a national level, things to do with education, health, pensions, those sorts of things, we don't see the same sort of legal intervention by the European Union. We don't see the same sort of laws being adopted, creating rights, creating benefits, the sorts of things that a member state does, the sorts of things that a nation state does for its citizens in terms of social policy, the EU doesn't do. What it does do, however, is that EU law creates a right for the EU migrant, that is the EU citizen that is moving from one country to another, to have access to another country's social systems, social welfare systems, on an equal basis as a national of that destination country. Now, it's not an absolute rule, and there are various conditions that may need to be fulfilled before you get access to those benefits. But as a general rule, there is equal treatment for EU citizens that are moving from one state to another. There are still very large areas of social policy which are designed, run, delivered, funded at national level. We should remember that we've got some very different models, we've got some very different families of social policy across the European Union. Our system looks very different from the Danish or the Swedish system. And in turn, that looks different from a Mediterranean, Italian or Spanish system in terms of who is responsible for providing social welfare and how it is funded. Whether it is provided universally for everybody without contributions, direct contributions, or whether it is provided through some form of insurance scheme that the individual is insured against various risks. Now, the EU doesn't stop these different models or these different families of social policy from existing. What it does say is that if you are moving from one country to another, you have access to that system on the same terms as someone within that country. Now, the member states are also part of international organisations, such as the International Labour Organization, which also sets standards. So whilst we might leave the European Union, we may still be bound by international standards in the social field. But the important thing about EU law that we have to recognise, and the thing that makes it different from a lot of other treaties that we might be part of, is its enforceability, for its ability to be used, to be relied upon before courts and before the national local courts. So whilst we may have similar provisions in international law, they won't have the same degree of enforceability. In the future, if the UK votes to remain, would that mean that we would see a lot more EU legislation being adopted in the social field? Would we see more social legislation? And I think realistically, we've got to be doubtful about that. And that's for a number of reasons. First, we're generally seeing a slowing up of laws coming out of Europe. It's not just the UK that may have concerns about the EU doing too much. It's a feeling that's shared amongst a lot of countries. In the Commission, we have key senior figures who have very clearly made the point that they think that the European Union should be doing less, but doing it better. And so over the last few years, we've seen a real slowing down of the lawmaking process in terms of what's coming out of Europe. We've also got agreements that have been made with the UK and the other member states back in February that said we're going to seek to ensure that the European Union is as competitive as possible. And that would mean looking at the laws we've already got and any potential laws for the future to say, is this really necessary, or would this be an unnecessary hindrance on the European Union's competitiveness? Also, there are now 28 member states, and we have to get agreement between those states when we're adopting legislation. In some areas, that agreement has to be by a majority, and in some other areas it has to be unanimity. But even in those areas where it's simply a majority, it's still difficult to get that number of countries all saying yes to a particular measure. Now you're going to discuss amongst yourselves, and here are some questions you might like to think about. Do you think that the EU should be involved in social policy at all? Do we need the same level of employment rights across the European Union? If the UK left the EU, do you think we'd see a change in the employment law rights and social policies in the UK?